morning. I am Jeremy Fogel. I'm a U.S. District Judge in California when I'm not working at the Federal Judicial Center, but I'm there full time now and have been for 3 years. And one of our policy priorities is public education. It's something that's very important to the federal judiciary, and we're absolutely thrilled to be working with the National Constitution Center. It's a collaboration which has been going on for some months, and we hope it'll go on for some years. It's a wonderful organization, it's a wonderful place, and we're happy to be doing this inaugural program. I have roughly 30 of my judicial colleagues from both appellate and trial level courts around the country who are here. We're going to be spending some time this afternoon and tomorrow talking about what goes on here this morning, but this is really an important part of the overall program, and that is reaching out to the public, talking about issues that are of concern to us, and giving you an opportunity to talk with us. So I'd like to introduce the two historians who are with me in this first group. To my left is Burt Neuborne, who is a professor at the New York University Law School and director of the Brennan Justice Center. He is, among many of his talents, a Madison scholar. He has a book coming out about Madison very soon, which he may say more about, but it talks about what he sees as the harmony within the Bill of Rights and the logical framework that Madison was trying to promote. And to my left is David Stewart, who is a very distinguished litigator at the firm of Ropes and Gray, and also a Madison historian. He's written several well-known publications about Madison and the other founders. His best-known one about Madison was published in 2007. And we're going to talk about the significance of Madison to the federal judiciary and in our understanding of the Constitution. One of the things that helped this program come into being actually occurred about a year ago. My wife and I went to, actually our intention was to go to Monticello. We live in Washington, D.C. We'd never been to Monticello, and so we said, well, let's go see Monticello. And we didn't even think about Madison. We were going to see Jefferson's home at Monticello. And on the way to Monticello, we took the back road through this really pretty part of Virginia, and there was a sign as we approached Orange, Virginia, that said Madison's home in Montpelier, and we just kind of on a whim decided to go there. And we ended up spending half a day at Montpelier. It was just a really inspiring and interesting experience. And I remember the attitude of the staff there. I'd say it's fair to say they had a tremendous chip on their shoulder, because they feel that Madison just doesn't get enough credit. You know, that Jefferson got all the glamour, and everybody wants to go to Monticello, and Monticello's on the nickel and all that kind of thing. And Madison actually was the guy who got the Constitution done, and who had many other very significant roles to play in our constitutional system as we know it. The historian at our shop, Bruce Ragsdale, is a very distinguished historian who works at the Federal Judicial Center, said, well, the problem is, though, that Montpelier is always going to be in the shadow of Monticello. Because it is. I mean, there's the mountain that Monticello is on and overshadows Montpelier, but I had developed a tremendous respect for Madison and all of the work he did. And we're going to focus on a few of these topics that were of utmost concern to him. One was religious freedom, another is freedom of expression, and another one yet is federalism. We'll talk about all those in the course of this session and the next. But that's by way of an introduction. I'd like to just turn to Burt and David and ask you each to tell us what got you interested in Madison. I told you my story. What's your story? Burt?
Well, I'm here under false pretenses. Let me get that right out.
Yeah.
I don't consider myself a great Madison scholar or a great Madison historian. What I've been throughout my career is a practicing constitutional lawyer. I was the national legal director of the American Civil Liberties Union for a number of years, the legal director at the Brennan Center now. And so much of my professional life has been engaged in attempting to read the Bill of Rights, to actually give concrete meaning to the often Delphic words that get used in the Bill of Rights. And it occurred to me one day, about a couple of years ago, that Madison is, of course, one of the principal driving forces behind the Constitution and the Bill of Rights, and that Madison is also Jefferson's indispensable political lieutenant. He actually got the things done that needed to get done. He also served extraordinarily well as the fourth president. But we will never honor him appropriately until we view him as a great national poet. Not a literary poet like Wallace Stevens or Robert Frost, but a poet of the intersection between democracy and individual freedom. And that the Bill of Rights should be read not as a series of isolated words or phrases where you take the First Amendment and take the Free Speech Clause out of the First Amendment and look at a few words in the Free Speech Clause and try to give it meaning. The document should be read as an integrated whole, as a great poem, the way you would read a great poem. You would never tear a word out and just look at it. You read the entire poem to get the story, the essence of what the poem tells you. And so I began a project that said, what if I read the Bill of Rights and asked you to read the Bill of Rights with the same intensity that you would read a Wallace Stevens poem? Is there music in Madison's work? Is there poetry? Does it tell a story? I think the answer is yes, and I hope that we'll get a chance to talk about what that story is. It is a brilliantly organized document. There is not a word out of place. There is not an idea out of place. The horizontal organization of the 10 Amendments, the vertical organization of the 10 Amendments tell a wonderful story to us, but we've lost the ability to hear it because we're so used to reading fragments that we never reconstruct the entire whole. And so that's my new book is called Madison's Music, and its attempt at reconstructing that music. And this is the first chance I've had to talk about it in public, and someone will probably throw a net over me and carry me away because I get excited about it. But I look forward to discussing it.
And we'll get into some of that in just a little bit. David, what got you interested in Madison?
Well, I've been poking around in early American history for a while, and the first book I did, as you mentioned, was on the summer of 1787 about the Constitutional Convention, and I actually, Madison is all over that. We read his notes of the convention. But I came away deciding he wasn't the father of the Constitution, that there were other people as important, even a couple arguably more important, and continued to work in the area. And I kept coming back and thinking about Madison, a bit like you, feeling, well, why don't I pay more attention to him? Why, he's there for the calling of the convention, the Annapolis Conference. He's there at Philadelphia. The ratification, the Federalist Papers, the Bill of Rights, the founding of the Republican Party, the Louisiana Purchase. He's our first war president, the War of 1812. But we don't notice him much. And I kept thinking of him as sort of the Zelig of American history. He's there, but you don't see him. He's short. He's skinny. He's got a soft voice. And I developed this notion that he was a different kind of leader and one we don't value as much, both because of his intellect, but also his personal style. He was an extraordinary partner, and that's the principle. I have a book coming out in February called Madison's Gift, and his gift was his ability to form remarkably productive partnerships with very different people. And 5 I focus on are with Alexander Hamilton in connection with the Constitution and the Federalist Papers, with Washington in founding the government and the Bill of Rights, with Jefferson founding political parties, something they neither would take a lot of pride in probably today, but they did it. With Monroe in the War of 1812, and of course with Dolley for his whole life. And I think those qualities of partnership, that ability to sort of check his ego at the door and work with other people, was a remarkable gift and one that we would benefit us to pay attention to.
Great. So this is a joint project of judges and historians. So in terms of those of us who are federal judges, what do you think is, in an overarching way, what can we take from Madison? We'll get into specifics in a minute, but I mean, what is the, if there was one lesson he has for us, or one perspective that the judges need to think about when they think about him, what would that be?
Well, I think Burt's talking about that in his poetical enthusiasm, but I think he is the fellow who worried all the time about how do you balance liberty and stability? How do you recognize rights and still have a government that can do things, that can hold together, that can be respectable in the world? It's not easy, and we struggle with it every generation. And that, I think, is his great gift. One of the things I became impressed with was his views changed over time on many issues. Power of the central government, what powers of state should be. He would have experiences and he would decide, maybe we should push it a little more this way. So he wasn't sort of an ideologist, a pure theorist. He was a practicing politician. But he cared most about how do we live together in a way that makes sense and also respects individuals. It's a great legacy.
So he was trying to find the appropriate balance between rights and responsibilities.
Very much.
Yeah. Burt, what do you think?
Well, I think David put his finger on it. I mean, he was not an ideologue. There were plenty of ideologues floating around in 1789, and there were plenty of ideologues floating around now. Madison was a self-taught lawyer. Never a member of the bar. Never went to law school. Taught himself the rudiments of British law, how it worked, how it functioned, and was a student of the actual functioning of institutions, and how they would work and how they wouldn't work. And if you watch him, for example, during the remarkable summer of 1789, when the Bill of Rights, the summer of 1789 is the meeting of the first Congress under the Constitution. It was ratified in 1787 and 1788, the first election, and the Congress meets for the first time. And the first item, a very important item on its plate, is the Bill of Rights. But its plate is very full because it has to literally create the government from scratch. So this is an incredible summer of intense work. And you watch Madison navigate that summer, knowing that he has a political obligation to put the Bill of Rights into the Constitution because the ratification process depended upon it. We couldn't have gotten the Constitution ratified in 1787 unless the powers that be promised the people that if ratified, the first thing they would do was put a Bill of Rights on it. The original decision to have a Constitution said nothing about a Bill of Rights, and the people demanded one. And that was the condition of ratification. So Madison took that very seriously. It was his obligation to fulfill that duty. And to watch him do that, to watch him jockey for time on the floor of the House, because there were so many other competing things that had to be done, and to watch him make deals, to watch him have his mind changed on things, and to see the Bill of Rights grow across that summer. That's what I think how Madison speaks to us today, and it particularly speaks to a judge, because the judge is the audience that Madison was writing for. The judge has to read that language and put it into reality in functioning institutions that actually work, and that was his genius.
So he was a big thinker.
He was a big popularizer. He didn't have a single original idea. All of his ideas, when I say original, it's unfair to ask him to have an original idea. What he was is he mastered the entire tradition from the Magna Carta, from 1215 on. There were 42 great source documents that he looked at, efforts by cultures, by the Anglo culture, to define their rights. And he had complete control of all 42 of them, and plucked from the 42 the ones that he thought would work and put them into the order that a lawyer would put them into. So it is a remarkable legal job of lawyering and historical work. It is not an original research job.
So he had a big enough mind that he could understand what people were saying.
Exactly.
But he was a pragmatist too. He was able to translate it into.
Exactly. And I wish we had people like that now.
So Madison's big splash, I guess is the best way to put it, what made him, what first drew people's attention to him was some writing he did about religious freedom. So David, why don't you tell us a little bit about that, about how that arose and what Madison was trying to say?
Well, Madison's an interesting fellow because he is this classic Virginia slave-owning gentleman. But then he goes to college in New Jersey. He goes to the College of New Jersey, now Princeton. And it was run by a number of sort of Scot Presbyterians. And he's very much exposed to the dissenting tradition in religion and has a great respect for it. And when he goes back to Virginia, he's struck. We don't really know if he felt this way before, but he chafes at the attitudes of Virginians towards religious diversity. The Anglican Church was rather monolithic. It had a lot of connections to the government powers. There were dissenting sects around, Baptists and Presbyterians, but they were not large in any means. And he's very much engaged with their sort of subjugation in some sense. With Jefferson, he shares this view. Jefferson develops the legislation which ultimately takes effect. And it's an interesting thing because Jefferson put that on his tombstone. It's one of the three things he wanted on his tombstone was the Act for Religious Tolerance and the University of Virginia, and I forget the third. But it was Madison who got it through the Assembly. Jefferson was in France when it happened. And it was Madison who was the practical politician who could make it. And in order to build this public attitude towards it, he developed the Remonstrance on Religious Liberty, which is a very powerful statement of the need to respect and ensure freedom of conscience. And after it's enacted, he writes Jefferson and says, with great pride, I think we never again will people try to restrain human consciences. It's uncharacteristically prideful statement by Madison, but it was terribly important to him.
It didn't quite turn out that way.
Probably not.
Yeah. But so say a little bit more though. What was going on in Virginia at the time that he was pushing back against?
Well, there was a push led by Patrick Henry, and Patrick Henry was, of course, an immense political figure who was Madison's nemesis. At one point, Jefferson writes from France, well, the only thing we can do with Governor Henry is hope that he dies. And Henry wants legislation which basically will institutionalize the connection between the state government and the church, will support the church with public revenues. And that's what Madison is trying to push against and ultimately succeeds in defeating and also getting his own, or Jefferson and his legislation adopted.
So Burt, when we were talking last week, you said it's really significant that religious freedom is right up at the top. And so say more, yeah.
It's no coincidence that if you look at the structure of Madison's First Amendment, now when I say Madison's First Amendment, David realizes, and those of you who are Madison scholars realize that that's a simplification, that Madison was the person who was carrying the lead ball here, but there were lots of people that were helping him, and the editing went on constantly, and the Senate eventually had something to say about it, and a conference committee. So it's an oversimplification to call it Madison's First Amendment. But I think it is fair to say that Madison drove the ethos of it. And it's no coincidence that it begins with religious freedom. The First Amendment has 6 ideas in it. It has no establishment of religion, free exercise of religion, free speech, free press, freedom of assembly, and freedom to petition for redress of grievances. And those are those 6 ideas in that order. No one in the history of the 42 source documents, in the history of trying to do this, to write stuff about rights, had ever put those ideas in that order. It still is the only document, including the Declaration of the Rights of Man, including all the great constitutions that have come later. It's the only document that has those 6 ideas in that order. And Madison chose to open with religion because he believed that you cannot have a democracy without recognizing the freedom of conscience of free people. That's where democracy rests, on the shoulders of a free people who are content with themselves before they can rule others. And they have to be able to live free, with a free conscience. There's a 3rd clause, a lost clause. Madison urged that summer of 1789 to adopt a conscience clause. In addition, he wanted to open it with 3 clauses. No establishment, free exercise, and freedom of conscience. The freedom of conscience clause drops out during the negotiations during that summer. Ironically, of course, it comes back in because you federal judges put it back in. Thank you very much. So it does come back in. But he understood that that's where you start. You don't have a functioning democracy unless you have a person with a free conscience and freedom to think.
And he starts off with the establishment.
And he starts off with establishment. Interestingly enough, during that summer, the order occasionally flipped. Sometimes they would have free exercise first, sometimes they would have establishment first. I think he held out for having establishment first because he recognized that the single worst thing you can do to a human being in terms of dignity is to force that human being to take affirmative action that the individual, that person believes violates his deepest belief. George Orwell knew it in 1984. The way you break somebody is to get them to betray someone. If you can get them to betray someone, you own them. And Madison understood that, and that's why it starts with establishment and then goes to free exercise.
Okay. So this tees up, now we'll put a fast forward to the present. So last year, the Supreme Court had 2 very controversial cases. They split 5-4. There's Hobby Lobby and Conestoga Wood Products. And both of them involve the contraception mandate and the Affordable Care Act. And the question was whether the owners of these 2 corporations, they were closely held family corporations, should be required to comply with the contraception mandate even though it contravened their religious beliefs. So what do you think Madison would have thought about that? Or if you're trying to draw a line, no, not an easy question, but I mean, if you're trying to draw a line from Madison's writings back in 1789 and before and after to the issues that were at stake in those cases, what light do you think his writings shed on that?
I have to say, I always find myself feeling like Justice Alito, which is a very unusual feeling for me. There was an argument over violent video games when Justice Scalia was harassing the lawyer and saying, trying to find out what they would have thought about it in 1789, and Justice Alito sat forward and said, what my colleague wants to know is, what did James Madison think about violent video games? And the White House just did that, actually. They tried to blame Madison for the Ebola mix-up between the states and the federal government. My gut feeling is that, again, he was a pragmatic fellow, and I think he would have noticed the rights of the employees, which are also at stake there, and would have looked for a way to respect both, which I think didn't happen. And this also gets snarled up into the question of, what are the rights of corporations, which is an idea he would have had a lot of trouble with. It was not a developed legal concept at the time, so I find it a little unpredictable, but I do think he would have been skeptical of the outcome we have.
So it wouldn't have been an either-or for him. He would have looked for some way to strike a balance?
He almost always did. Yes, I think so.
Burt?
My sense, agreeing with David again, my sense is the first thing Madison would say is, what's a corporation? Because the idea of profit-making private corporation didn't really emerge into the American legal sphere until Jacksonian democracy. It wasn't up before Jackson. In order to have a corporation, you had to have an act of a legislature, and only the insiders could do that. And it was a very political thing whether or not you could have a corporation. Jackson campaigned on the fact that this should be available to everybody. And slowly but surely, off-the-rack corporations were possible, culminating in New Jersey's corporate law in 1890 that allowed corporations to own other corporations. So that it took about 60 years for this to evolve, and this was completely foreign to the founders' generation. The founders' generation, if we're serious about originalism, they would know less about corporations than they know about violent video games. I mean, it is completely outside their... Now, having said that, I think Madison would have had a take on this. He would have said, if it's a very small corporation, and query whether Hobby Lobby fits that, because it had 11,000 employees. But if it's a very small corporation, with just a couple of owners and like a family that happens to be incorporated.
Well, that was the case
That was
in
the second.
Conestoga, yeah.
Yeah, that was the second case that was joined with a truly small corporation. I think Madison would have had sympathy to try to find a way to accommodate the deep religious beliefs of the owners. But what he would have said is, can I do it without shifting the cost of giving their religious belief to the employees? Because the one thing Madison refused to allow, and that's what the remonstrance was all about, the one thing that Madison refused to accept was that somebody's deeply felt religious beliefs could force somebody else to pay for them. That's why he was opposing Patrick Henry. That's what Patrick Henry wanted. Now, if what you say, if you view the Affordable Care Act case, if you view Hobby Lobby as a case in which the owners shift the cost of their religious beliefs to the employees through lesser coverage, Madison would have hated it, and Madison would have said it's a violation of the Establishment Clause. You cannot do that. You cannot use law to shift the cost of religious belief. That's why Justice Alito starts the opinion very carefully, and the verdict is out on whether he was correct in terms of fact. He starts that opinion by saying, this is a zero-cost case. He uses the word zero cost very carefully to say, we can recognize their religious beliefs without costing the employees anything, because the insurance companies have agreed to provide them the same coverage for a slightly diminished premium, because the insurance companies realize that it is cheaper to insure contraception than it is to pay for the birth. And so that they have agreed essentially to bear the cost of the owner's religious beliefs without passing them through to the employees. If that actually works, I think Madison would have cheered Hobby Lobby.
Even though corporations, as we know them now, in your assessment, didn't exist, and contraception certainly didn't exist.
That's right. But I think he would have said, in the world that we live in now, if it's possible to find a way, he would have said General Motors, for example. Of course, this doesn't work. The shareholders of General Motors have no intimate connection with the operation of the corporation. But a small family corporation that is just incorporated for technical financial reasons, that is really a small business, he would have tried to recognize their beliefs, but only if it didn't cost anybody anything. And we don't know yet whether or not the insurance companies are going to keep that deal. If the insurance companies keep the deal, I believe Hobby Lobby will be seen as a triumph for religious freedom. If they don't keep the deal, then we're going to be confronted with a very, very hard.
So this leads to a sort of an obvious follow-up question. The dissenters in Hobby Lobby said, where does this stop? What if somebody's religion sanctions or requires discrimination that's otherwise illegal, or something like that? So What about that? Do we get any insight? I think maybe both of you have suggested what you think Madison's answer would have been.
He is going to, he is the original balance person, and if there is a situation where in order to serve your religious beliefs, you have to disable somebody else or punish them in some way, even if it's financial, if it's inhibiting their psychic experience of their own freedom. That's not what he's not okay with that, and he's going to say you have to figure out another way to respect your religion. And he's going to try to avoid, I think, absolutist results, but he's not going to go along with something that reduces other liberty. His notion, he talks about it in another context, but his notion of many factions. He talks about this with religion too, that it's actually lucky that there are so many different forms of religion in our country, because that creates less totalitarian views. So I think he's going to want to indulge that to the maximum degree possible until it inhibits somebody else.
Is it a fair summary to say he give as much freedom as possible for people to practice their religion and have freedom of conscience, but not if it impinges on the rights of somebody else to do the same?
Yes.
Yeah. Burt?
Yeah, I think the pressure will come because I agree. I agree with what David said. The pressure will come at a point if the insurance companies back off. If the deal they made was a deal that operated only because of the small numbers of employees involved in that particular program, if when we take this to scale, the insurance companies say we're not prepared to eat the greater coverage with the lesser premiums, then we're going to have huge pressure to use federal funds to subsidize. In other words, to protect the employees by making sure that they get the same coverage, and to protect the rights of the religious rights of the owners by essentially subsidizing the coverage. And that is going to raise a very difficult establishment clause case, because that means that you and I are paying for the rights of the owners. We're subsidizing their rights by tax payments, which is exactly what Madison said in the Remonstrance you cannot do for religious beliefs. So I'm afraid that if the deal falls apart, if the insurance company deal falls apart, we're on a collision course with the Establishment Clause. And if the Supreme Court says you can do that you can force taxpayers to essentially subsidize the religious beliefs of someone else, I don't know where that stops. Yeah. That I think eats up the Establishment Clause.
And that's what you meant by saying the jury's out. So let me ask you one more religious freedom question, then I want to shift gears to something else. So the Supreme Court decided another very important case last year called Town of Greece versus Galloway, and it had to do with legislative prayer. What they said is it was not a violation of the First Amendment for a city council to open the session with a prayer, and also it was not a matter of constitutional significance that, as it turned out, just in practice, almost all of the prayers were Christian prayers. What do you think, how does Madison illuminate that situation?
I approach this public prayer, particularly in legislative setting, from a personal standpoint. My wife is a member of our county council in Montgomery County, Maryland. She has been there for 12 years, and one of the things she was surprised by is, as she says, how often we get prayed over. And she thought they were there to work on the zoning code. And I think it is more troubling, and Madison would find it more troubling than the court did. Because, and I don't mean to be flip about it, you're at a county council meeting to work on the zoning or to work on minimum wage or whatever it might be. It's not a moment of religious observation. It's not your freedom of conscience. And it is done for purely symbolic reasons. Nobody in that room is having a religious experience. They are just indulging this clergy person. and then going through the ritual, and then, okay, now we can do our business. So that very character of it as a symbolic act is what's objectionable, I think, to Madison, and it is an establishment of religion, which we should be more concerned about.
Burt, do you see that differently?
Well, first of all, I have to take responsibility for that case. I lost the antecedent case before that, in which the Supreme Court back in the 70s held that congressional chaplains were valid, and therefore the Nebraska unicameral legislature could have its own chaplain, even though it looks like an establishment clause to have an official chaplain for the legislature. And the Supreme Court pointed out that Madison voted for a chaplain for Congress when he was a member of Congress, and therefore they said Madison wouldn't have cared. Madison thought that it was okay because after all he voted for it. Now what they ignored was that later in life Madison said the one vote that he felt worst about in his whole life was the vote in favor of the chaplaincy, and he said, I did it out of pure expedience. He says, and what it did is taught me the difference between what a politician has to do to survive and what a judge should do in a principle basis to enforce the law. He said it was unconstitutional when I did it, but I did it. And that now has come down to us. We're haunted by Madison's vote because of the assumption that these kinds of symbolic religious observances in the context of governance are fundamentally harmless. And why are we so upset about it? And the problem is that it essentially denigrates the importance of religion. It reduces religion to a kind of white bread symbolism that doesn't mean anything to anybody. And what offended me most about the Supreme Court opinion is they seem to say, we don't understand why these people are so upset. All they had to do is just go and stand there for a second. They don't have to listen if they don't want to. And the answer is, it's the dissenter's conscience. Most of us are never upset by what government does. I wouldn't be upset if I had to pay a tax to pay for somebody else's religious belief. I would actually think that that would be a good thing. But my friends would be unbelievably opposed to it, and therefore the Constitution says that we worry about their conscience. We should be worrying about the people in that community who have to go up and ask for a zoning variance, or have to go up and ask for something that council is going to give them, and have to stand there and bow their head while somebody invokes Christ in that room, and the people don't believe in Christ. But they have to pretend they do, because in order to get what they want from the council, you don't start by insulting them. And I just think the court completely underestimated the psychological force of being forced to endure something like that. It is important, and Madison knew it was important, and I wish the current Supreme Court majority realized how important it was.
But to be fair, we do have as you found out in your case, there's a long string of cases that say these symbolic kinds of things.
Oh yeah,
in God we trust on the money.
In God we trust.
Yeah,
I mean, beginning
Pledge of Allegiance.
God save this honorable court.
Yeah,
That's the way the Supreme Court opens, and it opens because it's treated as symbolic. But it seemed to me this is further along. You have to, you can walk out, you can sit down, you can express your dissent, but then try to ask for the zoning variance. So it just seems to me to be a much more coercive behavior than the ordinary symbolic stuff.
I suspect that we haven't heard the end of this debate, for sure, because there's as I said, a long string of cases that suggest symbolism. Let's spend a little bit of time talking about free speech, if we might. And I think when we get there, we actually will end up talking about federalism as well. So the Alien and Sedition Acts come out in the late 18th century, and it's kind of a 18th century version of trying to fight terrorism. They were worried about foreign spies and all people from England and France and all of their problems spilling over here. And so the Alien and Sedition Acts are passed, and Madison has very strong views about them.
You want to tell us a little bit, David?
Yeah, we tend not to appreciate the amount of the crisis we were in the late 1790s over this battle with France, and we had an undeclared war with them. And the Federalists in Congress and Adams adopt these statutes. And the standard is remarkable under the Sedition Act that you're not allowed to say anything or print anything that would call the government or the president into disrepute. Now, you couldn't tell a joke about politics with that standard. And they started putting editors in jail. And Jefferson and Madison were terribly upset about this, both for principle and also political reasons. And they had to look around for how do we stop this. Congress wasn't going to work. The presidency was in the wrong party's hands. The courts were, every judge had been appointed by the Washington and Adams administrations. They weren't going to get a hearing there. So they turned to the states. And they drafted the Virginia and Kentucky resolutions. And I need to be very specific about this. Jefferson drafted the Kentucky resolution, which goes too far and uses the term that the state can nullify federal law. Madison drafts the Virginia resolution. They actually do it separately. And it doesn't quite go that far, although he goes right up to the line. He uses the term that the state can interpose. They're adopted by the state legislatures with some changes or amendments. And they asked for all the other states to join them, and none of the other states joined them, which is a bad moment, I think. And I think 10 states actually repudiate them. Other states simply refuse to adopt them. So they're stuck with this sort of messy political thing, and they end up, Madison goes into the Virginia Assembly, he gets elected, and he writes a report. It's his report of 1800, and it's a very underappreciated document, I think, and it has some wonderful passages in it. He does two things. One is he tries to basically bring Jefferson back from the ledge and say, the states have a role here, they have a voice in constitutional interpretation, but he stays away from nullify, he stays away from the notion that the states can change federal law. But the other thing he does is he says, and you're missing the point, which is the inhibition on speech. And he talks about speech in that report, and God help me, I'm going to use the actual language because it's so good. It's very modern language. He says, the press alone, checkered as it is with abuses, the world is still indebted to it for all the triumphs which have been gained by reason and humanity over error and oppression. That's pretty full-throated defense of free speech. And he anticipates the whole chilling doctrine, which courts didn't get to for a century. It's better to leave a few of its noxious branches to their luxuriant growth than by pruning them away to injure the vigor of those yielding the proper fruits. And I think that's very powerful stuff. And he really was way ahead of his time in his appreciation for the importance of these activities. And it became snarled up with the federalism issue, which we still get snarled up in. But I think on the speech issue, this was just the most powerful statement.
Sometimes we forget, in the burst of self-congratulation that we like to engage in as a nation when we talk about free speech, we forget how truly profound the Alien and Sedition Acts were as an act of censorship. President Adams, trying to hold on to power, locked up 17 of the 20 newspaper editors that opposed his reelection under the Alien and Sedition Act. The only Jeffersonian congressman from Vermont, Matthew Lyons, who was also a newspaper editor, was jailed for 4 months for criticizing.
And reelected from jail.
And he was reelected from jail, and he got the final word because he then got out, was reelected, sat in the Congress that voted to make Jefferson president, and essentially voted to end Adams' reign. So he had the final. It was a wonderful poetic justice. But Madison is fighting both publicly and behind the scenes trying desperately to end this. The lesson I take from this, which is a very powerful lesson, is that you can't use originalism to read the First Amendment. Because if you really want to be an originalist and go back and recapture what people thought the First Amendment protected, Madison was talking in the modern voice, but he couldn't get a federal judge to go along with him. Indeed, the federal judges were commencing the prosecutions themselves. He couldn't get a federal judge to go along with him. He couldn't get many people in Congress to go along with him, and he couldn't even get his allies in the states to go along with him. So that it shows the weakness of the free speech principle at the time of the founding, but it also shows Madison's remarkable prescience that you can't have a democracy unless you have free speech. I mean, that's why speech follows the religion clauses. You have the religion clauses in the First Amendment, and then freedom of speech is next, because that's the articulation. And then press is mass articulation. And then assembly is collective action. And then petition is actually putting it into law. So he's writing the arc. He's writing the odyssey of a democratic idea that starts in the conscience of a free person, is articulated, is distributed en masse, is the subject of collective action, and it's finally passed. It's a story of democracy. Yeah. It is democracy in action.
You know, it's funny, what both of you were saying in a way is that, if you were to put this in modern terms, if you had tried to argue that you shouldn't be very aggressive in going after people you think might be spies for France, that argument would not have prevailed politically at the time.
Right.
It was a losing argument.
Yeah, and it was a radical argument. It had been rejected in Great Britain. And it was,
so, you know, criticize, it's at that time nobody really had a problem with laws saying you can't criticize the government or you're going to go to jail. But they...
Well, tyrannical majorities didn't have a problem with it.
Yeah, but the only effective political strategy actually was to rely on the notion of federalism and the rights of the state.
Yeah, and it's important to realize that ultimately it's the people that ended the Alien and Sedition Acts. The people rejected it in the election of 1800. Jefferson, when he became president, pardoned everybody who had been convicted under it, and the new Congress refused to renew the act. So it's ultimately our first protection of free speech comes not from judges, comes from us. Comes from the people.
But Jefferson then prosecuted editors himself under state laws.
That's right. Jefferson himself did it himself. It's true.
So we have about 8 minutes, and we have a number of questions, which I'd like to get to at least some of, but we won't be able to get to all of them. But I'd like to circle back, if we might, to the Hobby Lobby and Conestoga Wood Products. So, you know, in listening to both of you, there's a sometimes, as an old law professor said, you know, if you let the law professor state the question, you know, you've lost. You know, so there's a framing part of this whole thing. How do you frame the issue? Is this an issue of individual religious freedom? Is it an issue of imposing costs on people? One of the questions is, well, what about the notion that the plaintiffs in the case, Hobby Lobby and the owner in Conestoga, were being forced to enter into contracts that violated their religious principles, that the law was actually requiring them to do something that violated their conscientious beliefs?
Well, you have a couple of problems there. One is the corporate form. You have a Quaker who happens to work for General Dynamics, you know, and they sign a defense contract. I mean, those are things that I think are not constitutional violations. Those are individuals. Now, Burt has posited the very small family corporation where it is an identity between the person and the corporation. Then it does become more of an issue, and I'm somewhat persuaded by his notion that you can try to come up with a way to respect those rights. And they are not trivial rights. I don't mean to suggest they are. But I do think you have to look at, is that a justification for employees who happen to be working for this person, happen to be in that business, to have different rights from other Americans? Is that okay too?
Well, taking the question head on, because I think it's a fair question. We continually require people to do things affirmatively that they believe are a violation of their religious rights. Many people believe that taxation violates their religious rights in certain situations. And the Supreme Court has rejected that. And they said, no, everybody has to pay into the common pot, even if you have a valid religious reason not to want to pay that tax. This is particularly so, for example, Amish, the Amish, argue that they shouldn't have to pay Social Security taxes because they take care of their own. And they take care of their own elderly, and they don't need help from the government, and it's a violation of their religious conscience to be forced to pay the tax. The Supreme Court rejected it out of hand, saying we can't start essentially giving people the right to carve out exemptions from the obligations of citizenship based solely upon their religious beliefs. So if there is a very powerful reason to ask you to do it, such as serving your country, there's no free exercise defense to the draft. If they draft you and you say, I hate war, it's against my religion, there's no constitutional guarantee. Thank goodness Congress has passed a conscientious objection statute, but it's not in the First Amendment, and the Supreme Court has rejected it, saying that there's no religious right there. Now, once you start down that road, you begin to realize that merely saying, oh, I'm being forced to do something that I don't like is no defense. At that point, you have to explain why there's no real reason to make you do it. And if the government hasn't got a real reason to make you do it, then you get a free exercise out. But here they have a real reason to make you do it because there's no other way to get an insurance program that will actually work in the marketplace.
So this gets back, though, to what you were saying earlier, actually both of you, about Madison being a balancer. You know,
He would have tried to find a solution that,
and it sort of depends on the importance of the public policy and the centrality of the right of conscience that's being supported.
that's
He would
right.
have tried to find a way to harmonize those things. One other question just on that topic, and it also spills over into something we didn't get to, which was the campaign finance cases that the court has decided on free speech grounds. And it goes to the question of corporations and whether corporations existed in Madison's time. And one of the questions suggests that the East India Corporation, which was the way that England did a lot of its colonial commercial activity, existed as early as 1600. Does that have any historical relevance to either of you?
Madison wrote this
Yeah.
Virginia legislation that created the Potomac Land Company that was developing the river. I mean, it wasn't that it was unheard of. It was that they were unique. There were 8 or 10. It was a big deal. And it was not a dominant form. The notion that somehow the corporation itself had rights other than what was written in the charter was totally alien. So, yes, of course, there were a few, but it was a very different animal, and I think, you know, if you bring the framers to 2014, there are 1,000 things that would make their heads explode. But corporations are one of them. It's just a totally different world.
yeah, video games. Well, we're going to talk about technology later on with the judges. Yeah.
So we have about 2 minutes. So
Well,
let me
I don't think there's any debate that corporations have First Amendment rights.
Yeah.
The New York Times is owned by a corporation. It has First Amendment rights. The harder question is, do those First Amendment rights translate into making unlimited amounts, into pouring unlimited amounts of money into the election campaigns? Is there some special reason to regulate the flow of funds in that type of political situation? And that's, again, I mean, this is special pleading, but that's why I think the structure of the First Amendment is so important. The First Amendment's about democracy. The First Amendment is about making democracy work. Madison understood that that was his job, and that's what he did. And the question is not whether there's some abstract First Amendment right that lets somebody do something and it's harmful to democracy, but we have to tolerate it anyway. The First Amendment is about democracy, and it should be read in a way that, now, you might say, a good democracy is a democracy that lets everybody say anything they want, including corporations. I'm prepared to have that debate. But it's a debate about the quality of the democracy, not some freestanding antecedent right that turns the First Amendment into an obstacle to democracy instead of something that makes democracy work best.
Well, we'll have more to say about that, I'm sure, this morning. David, you want to have any parting thoughts for the group before we take a break?
I think it's a great opportunity to talk about Madison, respect him. I do think one of the things I would flag, just for people to think about, is Madison's obsession with stability was something that he shared with his contemporaries, and it has resulted, you can blame him and his contemporaries for some of the gridlock that we find ourselves in. They wanted a government that would have trouble doing things, that would require an unusual consensus of people. We've got all these supermajority requirements. It's hard to amend the Constitution. The president can veto, the Congress can override. There are lots of things not in the Constitution, but the Constitution itself was designed to make things difficult to get done. And, you know, we have 2 houses of the legislature. If you only had a one-house legislature, you wouldn't get that gridlock. So that, we tend to glorify the Constitution and the structure, but I think we also need to be more skeptical and need to look at it as some of the things we don't like today can be traced to it, and we need to have more of an open mind about saying, you know, we could change that.
Well, and he said, Madison said in his writings back in the day that was on purpose. That
Absolutely.
He wanted limited government. He didn't want government to be overly efficient.
It was his intention.
Yeah.
But it's not always something
Right.
we're happy with.
Well, we are out of time. We're going to take a break, and then we're going to pick up this conversation in about 15 minutes with 2 very distinguished federal judges who have insights about Madison as well. But I would like to thank David Stewart and Burt Neuborne for their very wonderful insights.
Thank you.
And as we say in the court, we will be in recess for 15 minutes, and we'll start at 10.